Welcome to our webinar on open case rounds for U and VAWA Q&A. I'm Amy Chung, and I'm here with Gail Pendleton, our Executive Director at ASUSTA. And we're also grateful today for the support of the Office of Violence Against Women, OVW, who is supporting this webinar, as well as our overall project on technical assistance for OVW grantees. On the agenda today, we're going to be looking at some common trends that we've been noticing from TA requests, such as fee waiver denials, discretionary issues on U's, and some emerging issues on the periods of admission for U status holders. And then we've also left what we hope is some time for people to share their experiences, to share case questions that they may have for us or for other participants. So there should be some open time for discussion during today's webinar as well. And the goals for today are that by participating in the session, you'll be better able to identify challenges in presenting and preserving VAWA UNT visa applications, fashion strategies for meeting those challenges, and also explore best practices. I also just want to note that we had a little technical issue, and so that's why there aren't any bullet points on the slides. But if you feel that bullet points would be clearer for you, they are in the PDF that you can download in the files box underneath the chat box on your screen. All right. And then before we get into the meat of the presentation today, we thought it could be useful to see what are some of the most common problems that practitioners are seeing in their work. And then also, if what you consider your most common problem isn't on the screen, if you could share it with everybody in the chat box that is at the upper right-hand corner of your screen.
Should have an all of the above, Amy.
That's true, that's true. But it's really useful for us because we don't do direct services to be able to hear from practitioners what are your most common problems, what are the issues that you most need guidance with or that we could most help you with in your work.
So this is helpful, Amy, right? Because we may not have to spend much time on the continuance issue, and we could spend more time on the other issue near the end.
Right.
Okay.
Yeah,
great.
it's also really helpful for us in terms of planning webinars and preparing practice advisors and things like that for us to know, where we should be spending more of our time. So I'm seeing some responses in the other columns. So if people who checked other or people who have very common issues that aren't in the poll wouldn't mind sharing in the chat box, that would be really helpful for us. Looking at this, it does look like a lot of people are having fee waiver denial issues, and so we will be talking about that extensively on today's webinar. Seeing some discretion issues, that's been a common theme, and some questions on being unsure how to advise clients given the new memos on NTA issuance and RFEs and NOIDs coming out of USCIS. So that's great. We're planning to talk about all of these things. And then, to the extent that there are other issues that people would like to discuss, we'll have a chance to do that too. I'm not seeing any other issues raised in the chat right now, so why don't we move on, and then as people want to raise other issues and discuss with us and with participants during the rest of the webinar, we can do that. All right, so let's start with fee waivers. As I'm sure many of you know, there have been more and more fee waiver denials coming out of the Vermont Service Center for the last few months, really starting around the end of July. And so this is a problem that we've been hearing about from many practitioners and an issue that we're well aware of. And so it's something that we wanted to talk about today so we can discuss what some of the issues are, and some strategies that we have for addressing them, but also giving everybody a chance to discuss the strategies that you've come up with in your own work. Okay, and Gail, I think this section is yours.
Okay, so as many of you know, there was an abrupt shift in how they were addressing fee waivers. One of our pushbacks, frankly, to them was they have not actually followed the proper procedure for changing their fee waiver policy. And as many of you know, all they've done so far is issue a form. And we will share after this the comments that we sent in on this, because I think there's a lot of arguments and kind of survivor perspective that might be helpful to you to start including as a general practice in your requests for fee waivers or responses to them denying fee waivers. Just as a background, as you know, Congress actually exempted the primary applications for victims of crimes from any fees. And so where you're really seeing the fee waiver problem is with what we call ancillary applications that USCIS has used to dealing with for many different kinds of applications. And in general, what we're seeing happen these days is they're applying policies that are really designed for the general immigration system without tailoring them to survivors of crimes. And I think this is a perfect example of that. So we definitely have some suggestions on what to do given their current approach, and also how to push back on their current approach. So, how many of you have successfully submitted a fee waiver request in the last 4 months? Is this a poll that, yes, yay. Okay, ooh, about half and half. A little more of you have succeeded than others. That's good news. Okay, I think that's pretty good. So I'm assuming the no's mean that you have gotten kickbacks on fee waivers. So we're going to get into the nitty-gritty on that now, I believe. Oh, no, another poll. Okay, so if they have approved your fee waivers, what was the basis for your request? Did you use the means-tested benefit, which people were using in the past? Did you use a general assessment showing that you were under the poverty guidelines at 150%? Did you do like a one-pager with financial hardship and or with documentation of financial hardship? And again, some of this may be an all of the above, but I think, are they allowed to vote for more than one? Probably not. Okay. Looks again like it's pretty well split. Okay, and I think many of you are not participating, and it may mean that you haven't been asking for fee waivers, so hopefully you'll learn something by watching what other people are doing with their fee waivers. Okay, let's go to the next slide. Okay, so as you know, part of the problem with this, which kind of implied, is that this creates economic hardship for survivors. And in fact, the reason Congress decided not to require applicants for VAWAs, U's, and T's to submit fees generally for their applications is they recognized, I think, first of all, economic control is often used by perpetrators of any of those crimes to keep their victims from fleeing or becoming independent. And because of that, even once they've left or gotten out of the perpetrator's control, they still will not necessarily have access to the kind of money needed for some of these fees, which can be pretty hefty, especially if they have a family and they're the sole provider for their family, and they don't yet have legal work authorization or they don't yet have access to public benefits. Where we're seeing this really, in my view, form a constructive denial of the merits of your application is where it's for something that has a deadline for replying. So what we're seeing, unfortunately, I hope it's not intentional, is them denying your fee waiver with like 2 days left for the appeal period. Or the day before you have to file an appeal or a motion to reopen or reconsider. And we especially want to talk with you about those cases because not only do we want to intervene with headquarters and with the heads of the unit, but we want to discuss with you other possible strategies for challenging that kind of what we view as an essential due process violation. There's also, even within their own application of the guidance, a lot of inconsistency. So we've also seen some of you contact us where you have complied with the heightened scrutiny and higher standard in the guidance that they're now using, and yet you're still being denied fee waivers. And again, you should raise those with us right away, because the way our intervention system works, and we'll discuss this with you again later, is we help you frame your response. Once you file your response, we ask you to forward that to the supervisor email system and CC us, and then we monitor what happens and take that either immediately or wait to see what kind of response they provide. We take that email to the heads of the unit and to headquarters, and we may even suggest you file a case inquiry with the Ombuds office, just to highlight the systemic problems that are flowing from this. And perhaps they will actually pull your file and fix the problem if it's clear that it's an adjudicator who is misapplying the law. And so that's generally how we approach the government on this. We don't say we think you should approve this particular. We say we think this is a training issue because your adjudicators appear to not only be not following your own guidance, and then we give the arguments for why they should apply the any credible evidence and that kind of thing, which we'll get to in a minute. So I think we're now back to you, Amy, on some specifics on how to respond.
Yeah. So based on what I'm seeing in the chat and what we've been seeing through TA for the last few months, there's been a lot of inconsistency with the adjudications of these fee waivers, right? And so in terms of strategies, we don't have a one-size-fits-all solution. We don't have a strategy where if you apply this, it will work, right? What we have are some suggestions for what we would recommend doing in these situations that we think will put you in a better position going forward for challenging the denial. And also, hopefully, that wouldn't result in a denial in the first place. But they're not guaranteed to work, right? And so that's where hearing best practices and hearing what's working from practitioners can be so helpful. All right, so in light of that, let's talk a little bit here about what you guys would do in this kind of situation. So let's say you have a U visa client who's a DV survivor who files a fee waiver for her 192, her waiver for of grounds of inadmissibility, and her 765 for her C14. She submitted a sworn statement of her income showing a household income under 150% of the federal poverty guidelines and her expenses, as well as copies of her children's SSI and food stamp award letters. And this is, let's say for purposes of this hypo, that this is all the evidence that she submitted in support of her fee waiver application. And so CIS issued a receipt for her U visa for the 918, but they denied the fee waiver request for the 765 and 192. And they told you that there was insufficient evidence without saying anything else about it. So in this kind of situation, if people could share in their chat box, how would you address this? If you got this denial for the 765 and 192 fee waiver, how would you address it? And this could be what would you do in terms of additional evidence, or what would you do strategically in terms of addressing this with USCIS as well? All right.
So,
go ahead, Gail.
Do you want me to read them to you, or do you want to read them?
You can read them, that's fine.
Okay, so Victoria said check to see if she filed that federal income tax, one of their requirements, and send that if she did.
Absolutely. USCIS does really like to see the income taxes. So if your client did file them and there aren't other problems with the tax returns, such as, perhaps a false social or other problematic information on the tax return, then that would be really great evidence to submit.
And what if they were filed by the abuser? That's often a big problem, right? And they're inaccurate. in one way or another. You
Well,
think people?
if they're inaccurate, if they're inaccurate, then I think it's more problematic to submit them. If your client didn't have, because the point of submitting the tax returns is to show USCIS that your client is unable to pay, right? And so if the information that you're submitting is inaccurate about her inability to pay, then it's not necessarily going to help your cause. And then Leah saying that she would encourage her to file taxes if she can and then wait till she gets those before resubmitting. That's an option. It may be a timing consideration. It's possible that with U visas, because they take so long to process by USCIS, that you might actually have the time to be able to do this. There are some other applications where you would be time limited in being able to have your client file taxes before resubmitting.
And we also think it's actually unlawful for them to be requiring any one specific kind of evidence, which I think we'll get into later. They, as you know, they seem to be completely ignoring the any credible evidence standard and the totality of the circumstances approach, both of which are the standard for these kinds of cases. But there's a difference between getting it approved and being right. So,
Right.
weigh both of those.
Okay. So we've got some other suggestions here. We've got bank statements, credit card statements, both of which can be helpful, but you always want to check them to make sure that the information on there is accurate. We've got a question from Magdalena. So even if they filed with a fraudulent Social Security number, they could use their tax returns. So that's one situation where we probably would not recommend filing the tax returns because using a fraudulent Social Security number would raise a whole number of discretionary and other concerns, potentially, with USCIS that go far beyond your client's inability to pay the filing fee. So that's a situation where we would encourage you to reach out for some technical assistance. Perhaps we could help you think of other things that you could submit that would satisfy USCIS. That's a situation where we might be concerned.
And I think you're going to get into how they can set up their own tax number, right, an ITIN. Do you know if it's still true that you could, it used to be many moons ago, that you could transfer taxes you paid into a fake Social Security number or someone else's Social Security number into your actual real one? I don't know if that's still true, but
I don't know. If somebody knows, feel free to share it in the chat. I would say that we're not planning to talk in depth about ITINs on this webinar today, but tax season is rolling around the corner, so if people have questions about that, please send us a TA request, and we're happy to walk you through that process.
And Leah suggested, what do you think if you redact the Social Security number from the form and send it in without it?
It's still potentially problematic, right?
Might raise questions with them. Yeah.
It could raise questions with them. USCIS could RFE you for it. It could be a red flag. It could also not be a problem, right, potentially, but I think there is some risk there that you're incurring.
Okay.
Some other suggestions include, for example, asking for supervisory review, sending a case intervention request to a SUSTA, and then also briefing in your cover letter what evidence you're providing, why it establishes your client's inability to pay, and really highlighting the any credible evidence standard that they're supposed to be applying.
Right.
Okay. All right. Now, let's say that you filed an appeal of a U visa denial on September 14th, and then you filed the 290B with a fee waiver request on the form I-912 with her pay statements and showing that her income is under 150% of the federal poverty guideline. And then they denied the fee waiver on September 20th, right? So, and then you receive the fee waiver denial on September 25th, a week after the 33-day period for filing the appeal of the denial has already expired. And so your issue at this point is that you had a deadline for filing the 290B for the appeal of the U visa denial, but because you received the fee waiver denial after the expiration of the deadline, your appeal is now late. So in this situation, what would you do? And if people have any ideas to share with everybody in the chat, that would be great. So Gail, in the meantime, while we're waiting for people to share their ideas, what do you think would be a way to address this?
Well, I believe what we've been doing in our technical assistance on this is suggesting that people still go ahead and file either a motion to reopen / reconsider or an appeal arguing good cause for missing the deadline. In general, I think it's a pretty good argument if the reason you missed the deadline is government delay and it was out of your control. But we would definitely want to help you with this because I think there are other things beyond going to the AAO that we may need to consider here. We may need to get some attention from the federal courts on what's happening on these issues. And we have a couple conversations happening outside of this webinar on that. So you should let us know if you're interested in that.
Great. And Lorena's also saying that she would refile the appeal ASAP with more evidence, taxes, the applicant's detailed statement, etc. I agree that that would be helpful if you do have more evidence. The issue is that in this case, in theory, you've already submitted the evidence that USCIS is asking for 912s, right, for these fee waiver requests. So, you know, in theory, you shouldn't have to provide more evidence because you already provided what should have been sufficient for this application. And so that's, you know, one of the issues that we're seeing where they're so inconsistent that even where people are complying with everything that USCIS is telling them to do, that these cases are still being denied or these fee waiver requests are still being denied. So as Gail mentioned, we do recommend that people late file the 290B appeal. Technically, there is, for the AAO holds that it's not possible to file a late appeal. We would still recommend doing this because there are issues of fundamental fairness and due process that are raised when you file timely, USCIS denied it, and then they sent it to you after the appeals period had already expired, right? And so there are arguments here that we would raise about this delay having been outside the control of the survivor, and then requesting that the AAO or USCIS reopen the case or potentially even reissue the denial notice with a new date on it so that you get a new appeals period. But this is a situation where we would definitely encourage you to reach out to us so that we are aware that it's happening and then also so that we can help you strategize about how to move forward. And then a couple other suggestions. We discussed this in our last webinar on appeals and motions to reopen and reconsider, but just to reiterate, if you're filing a late appeal, there's a pretty good chance that they won't adjudicate it as an appeal, but they are under regulation required to consider it as a motion to reopen or reconsider as long as the arguments and or evidence that you're submitting meet the requirements for such a motion. And then you can also, in the alternative, file a motion to accept a late filed motion to reopen with a new fee waiver or a fee, depending on how you decide to move forward on that. All right. So the missed deadlines issue for fee waivers also arises in the 485 context, especially for U's, where you're trying to file for adjustment before your client's U status expires. And so what we've been seeing is very similar to the issue around appeals expirations. We are seeing people who are filing the 485 timely before the U status has expired, but because the fee waiver is being denied, their adjustment of status application is now late. It's being resubmitted after the expiration of the U status. And so you have a couple of options here. Generally speaking, people would need to file a 539. At this point, it would be late filed because the status has already expired. So it's a nunc-pro-tunc U extension request. And you would need to show that the extension is warranted due to exceptional circumstances. right? And then you would also need to file a 45 with a request to accept a late filing. So you would need to explain why the 45 is being filed late. Historically, many people have filed 539s and 45s concurrently. And the issue has come up where there's some discussion about whether or not it's a good idea to keep filing concurrently or to file the 539 first. The issue is that if you're filing concurrently and it's late, at the time that you're filing the 45, your client is not in use status. And so there's an argument that your client is not properly filing the 45 because in order to properly file the adjustment of status application for use status holders, they must be in use status at the time of filing. Historically, and as far as we know currently, USCIS has been adjudicating the 539 first. So even if you file the 539 and the 45 concurrently, USCIS has typically adjudicated the 539 first. And if they do this, and if they grant it, then they backdate the approval back to when your client fell out of status, such that when they get to your 45, your client was in status at the time that you filed the 45. The question, I think, going forward is whether or not they're going to continue to do this, because they're not required to if you're filing concurrently. And if they got to the 45 before they did the 539, then there would be a problem because your client wouldn't be in status at that point, right? And so this has been an ongoing question, and so it's helpful for us, as Gail is noting in the chat box here, it's helpful for us to hear from practitioners whether or not this is still working for people, whether or not there have been any issues for people who are filing concurrent 539s and 485, so that we can check to make sure that the issue hasn't changed or evolved in any way.
And one of the reasons that we would argue back to them is that if they weren't taking so long to even open the 485 cases, this probably would be less of an issue. But people are having to do this because it's often taking a long time for them to get to your 485 case. So that seems like a good argument on our side for continuing to do the concurrent. And so far, none of you have said you've gotten a denial because you filed concurrently. Definitely keep us posted, okay?
I mean, one of the problems is that because it takes so long for either a 539 or a 485 to be adjudicated, we don't hear results until, a year after somebody has filed. So it is really useful for us to hear from people in the field as decisions are coming back in. Okay. And then, as Gail mentioned earlier, after you refile, it's time to advocate. So it's not enough just to refile. It's useful to submit an inquiry to the hotline. We've been hearing from a lot of you that responses from the hotline are either not coming at all or are coming very late. But then we are also hearing that there are occasional responses still coming through. So we do still recommend using the hotline, just with the caveat that the response time may be more extended or that you might not get a response. And then it's also possible to contact the USCIS Ombudsman through their online case assistance form, and then also request intervention through us.
Right, which is, I mean, that's why you have to do that hotline email, even if they never respond, is that they don't want us contacting them unless we've essentially attempted to use their own system to fix things. So it's not working it's 98% of the time it's not working, but it does work occasionally, and our interventions are still working occasionally. Even if we don't hear about it, we hear about it from you. And the Ombuds office is still occasionally fixing problems, so it's still worth trying. Okay, is it my turn?
Yep.
Best practices here. Okay, so even though we think they're applying the wrong standard and all that, it's still, assuming what you want to do is not have to deal with the problem until we get that fixed, you should go ahead and use the form and follow the form instructions. And then what we would suggest is making some of the arguments that we'll share with you in the comments we send in on this, that you could start cutting and pasting and just putting in to every response that, you're basically violating the congressionally mandated any credible evidence standard when you're doing this kind of thing. One of the ways that they are violating their own rules is insisting on systems evidence, which is primary evidence. As we said on the last webinar, it doesn't mean that the any credible evidence standard doesn't mean you don't have to show why it's the best evidence you can. But the reason Congress created that standard was they acknowledged that survivors often don't have access to the systems evidence that they normally rely on for, say, a family-based or business-based immigration application, or that systems evidence isn't going to reveal what you might want it to reveal because survivors don't want to share their experience with some of the systems. If you are using the means-tested benefit, you do want to make sure that it's not an unlawful use of the means-tested benefit. So I was kind of shocked when I heard that all these U applicants were getting means-tested benefits, but I think what it actually was in most places was their U.S. citizen kids were getting means-tested benefits. Now, they are saying themselves that they're not going to use those per se as evidence. We're fighting back hard on that, but in the meantime, I think you can take the evidence that's in a means-tested benefit to just articulate the facts to show that your client's under the poverty guidelines. And someone had raised, maybe this will come later. Let me ask you, Amy. Someone had raised, what about the public charge concern? Are we worried about that, or is that coming up later? With showing benefits.
Up later.
Oh, it is. Okay, good.
I would say that for public charge, I think it's important to keep in mind that U visa applicants, T visa applicants, and VAWA applicants, VAWA self-petitioners, are not subject to the public charge ground of inadmissibility. Public charge could come up in the future if they're applying for other forms of relief or remedies for which public charge is applicable, such as if they're petitioning for family members in the future or trying to immigrate through a family petition in the future, right? But for the U, T, or VAWA in and of itself, public charge is not an issue.
Right. So if you have questions about what might happen down the line on this, let us know and we can talk it through with you. Because in general, this has always been true, and actually why Congress over the years has exempted survivors from public charge is that they recognize that to get out from under control of perpetrators, they need to be able to access benefits for themselves and their kids. So it's the problem right now is that we don't think USCIS has been well educated on that lately. Okay, so if we already talked about the Social Security number, some of this is avoid fraud and credibility issues in what you file. So remember all the practice pointers we gave last time, which is you definitely want to check that anything you're filing in here, first of all, is internally consistent, even on things that may seem immaterial like dates and locations, and consistent with anything else they may have in their packet, because you don't want to be raising credibility and fraud concerns with what you're filing. We already discussed the taxes, and it might be a good idea, actually, as part of your system now with all of your survivors, is to explore setting up this ITIN number with them. Who knows what's going to happen in the future with taxes and what the Social Security system or the IRS may do. Right now, there hasn't been a lot of exposure, but you want to clean up your clients' lives as much as possible because we never know what's going to happen in the future. It used to be, many of you work for agencies where your own kind of triage of who you can take with clients was basically per se evidence that anybody you helped would need a fee waiver because they didn't have the income to qualify for other kinds, like a private attorney or someone else, and you are the agency's often of last resort for survivors who can't afford to file. Unfortunately, now just filing that, your triage system, how you decide which clients you're going to accept, is not enough. But it's still good evidence, right? It should be personally, I do think it should be enough. But use it as evidence to comply with what the form requires, and you may have to articulate how it shows that they're under the poverty, minimum, or just the lack of assets versus income, the general financial hardship that you should be able to show. Again, we hope that eventually they will go back to what they were using before. So again, what we're suggesting is to comply as much as possible and then argue why what they're required violates the law. And you, by doing that, are helping us push them to understanding they should go back to a more survivor-focused approach to fee waivers. So this is one thing that I know it's really hard for many of you to keep up with filing things early, and you have a tickler system, so you're often filing things at the last minute. You do not, if you can possibly avoid filing fee waivers close to deadlines for appeals and RFEs and motions, that would be very helpful. So file them as soon as possible so there's time to respond if they deny. And if it's in a situation where you're not losing, you're not constructively losing the application because you missed a deadline, then you do want to do an assessment of, is there any way we can get the money together and just refile, or do we want to fight this? Do we want to restructure what we've submitted? Do we want to talk to ASISTA and have them help us communicate with Vermont about why what we filed should suffice, which I would suggest you do in all of these cases because it helps us too. But the bottom line is you got to do what you got to do to preserve the relief, whatever that action is, and then we help you fight it. Because as I often say, the hardest thing to challenge is a denial based purely on procedure, nothing having to do with the merits, like you didn't file on time. That's really hard to fix. Oops, right. I think I did. Is this you now?
And then next?
Yep. Back to you.
So, next up, we're going to switch topics off of fee waivers and go on to this notice to appear memo that was issued back in June. So as many of you are aware, USCIS has issued a memo stating that if somebody's application is denied and that person is otherwise removable, then USCIS retains the discretion to issue a notice to appear to initiate removal proceedings in that case. The memo also walks through several other factors that would influence the issuance of a notice to appear, such as fraud, misrepresentation, or abuse of public benefits, criminal history, including egregious public safety and non-egregious public safety, to include cases where the client has been charged but not convicted or has admitted to criminal conduct. And then, of course, the catch-all is when there's been an unfavorable decision on a status-affecting application, such as a U or T visa application, adjustment of status, VAWA petitions, and the individual is not lawfully present in the United States. This slide is a little bit out of date. We made it several weeks ago before USCIS issued its latest statement on this. The NTA memo is currently in effect for humanitarian applications, including VAWAs, U's, and T's, right? And so what this means is that as of November 19th, if your client is out of status or otherwise removable and their application has been denied and their appeals have been exhausted, then there is a chance that that your client will be issued a notice to appear. Okay. And so the question that we're getting on this, as some people noted in the poll at the beginning of today's webinar, is that it raises a lot of practice questions for attorneys and DOJ reps and other people who are representing survivors as to how to advise their clients. How do you move forward on a case? One of the most common TAs that we're getting these days is, they have a case where they're just not sure whether it makes sense to move forward given the risks for their clients. And so we recognize that this is a really tricky time to be practicing. This is a really tricky time to be advising immigrant survivors as to their options because of the level of uncertainty and fear that we're all seeing. And so as a baseline, we do recommend advising your clients in writing about the risk of enforcement should their application be denied. There are organizations with a standard form or a standard letter that they provide to clients at the beginning of representation about the risk of enforcement. If your organization doesn't already have one, it's worth reaching out to see who does have one to find a model or to draft one yourself for your organization. But it's a really important step in, one, making sure that your clients actually understand the risks that they're undertaking when they file these types of application. And then two, also making sure that you have covered yourself in advising your client about those risks. And then in addition to that, it's really important to assess your client at the outset for other forms of relief, including both forms of relief that they could apply for before immigration courts if they're put into removal proceedings, as well as other remedies that they could apply for with USCIS. And I know that many of you guys are already doing this with your intake forms, and you're starting out with and by looking at what all of the forms of relief that your client might be eligible for. But I think it's also really important to reassess your client for eligibility for various immigration remedies throughout the representation. Because we're seeing such long delays in adjudication periods and processing times from USCIS, it means that people's circumstances change and even the law changes over time. You'll have clients who become eligible for remedies that they weren't eligible for before. You'll have clients who become ineligible for remedies that they used to be eligible for. And so just as you might have ticklers in your case management databases for checking in with clients, updating clients about case developments and things like that, it's worth having a tickler in there for reassessing clients for eligibility for various types of immigration remedies. And then we also recommend that as you're filing these cases that you're preparing to appeal to the AAO to defend your client in removal proceedings or to go to federal court, whichever the best option may be. It might be all three. It's important to make sure that your client is prepared for this, and it's important to make sure that your organization is prepared for this. We know that among OVW grantees, there are organizations with different levels of expertise and different levels of resources in terms of what services they're able to provide to clients. But now is the time, if you're an organization that doesn't have the resources to represent somebody in removal proceedings or to go to federal court, that you either create a referral relationship with another organization that does have those resources and expertise, or that you start thinking about how your organization could develop that expertise or develop those resources to be able to do it, so that your client's not left high and dry should the case be denied in the end.
And just one suggestion on that is, we have been running a listserv for 20 years, so we know people all over the country who do this. So if you don't know anyone obvious who you could partner with on this, let us know, and we can find people. We'll try to find people in your area you can work with.
Great. And Dale, I think you are back up.
Okay, sorry. I'm going to just go back and rant a little bit about this because two things, and I put some of this in the chat box. This is the perfect example of them applying a policy that's designed for the general immigration system but is inappropriate for survivors. The very fact that one of the reasons they're going to issue NTAs is that you're not lawfully present in the United States illustrates this, because that was the reason Congress created the U visa, was for undocumented crime survivors who were too afraid to access our system because they thought they'd get deported if they did it. So we're pushing back hard on this, and we really although we do think you need to develop all these best practices in case this starts happening, and survivors are going to end up getting put into proceedings more one way or another, whether it's through this or something else. But it also means we need to aggressively challenge the main systemic blocks that are causing unlawful denials, especially in the U visa. In the VAWA context, I would say that's an inappropriate good faith marriage standard. And in the U visa context, I would say it's the regulatory prohibition on review of U visa waiver denials. Those are the two main reasons that we see these cases being denied, and I think they're applying the law unlawfully. It just hasn't resulted in people getting deported yet. Now it may, and so we need to fight those problems at the stage that you're seeing them. So as you see those, let us know, and we'll fold you into our current efforts to challenge those systemic problems so that if someone actually is, I think the assumption of the system is if you're denied, you don't qualify, but we know that's not true with a lot of VAWAs and U visas. And it's probably, we know it's not true for some T visas too. And we spend a lot of time fighting with them about the denials. So we need to fix those problems before this NTA system should even be implemented for survivors. So let us know if you want to help with the fight back too. Okay, so this is actually a good lead into the inadmissibility problem. Now that we have not yet fixed the lack of review of U visa inadmissibility waivers, the discretion aspect of it, it's even more important that you set these up so it's easy to appeal them to the AAO and, if necessary, to the federal court. So this is the paradigm shift I've been talking about on previous webinars. I used to suggest, when the law was first passed and started being implemented, that you, first of all, include catch-all language in case you didn't know all the grounds of inadmissibility. That second piece, any and other grounds, don't do that anymore. I assumed that they would be able to figure out from your facts what the admissibility grounds are. They cannot, and so that's basically a useless catch-all strategy, plus even if they use it, you don't know what they're applying it to. More importantly, I used to say fess up and ask for forgiveness. No, don't do that anymore. At this point, we're back to being the lawyers who keep things in their pocket unless they are required to share them with the agency. So you only need to now provide the evidence that's material to your client's eligibility. You don't need to provide evidence that's not material and that may raise issues later on when they open the file, when anybody opens the file. And if you have questions on what that means in your case, let us know. We'll help you talk through that. There seems to be, I don't know if it's actually true that it's more strict on discretion. The problem is that there's no review of their discretion. The same people make it decide that they exercise their discretion adequately, and then the AAO is saying they can't review it at all. So I think although you want to respond truthfully, at this point, if you have issues like them asking for police reports or juvenile records or any of that, that's when you contact us and we'll help you figure out how to frame your response. You do want to cite some of this is review for many of you. You do want to literally cite every inadmissibility ground you want waived. And for instance, if you're doing unlawful presence, you want to cite all subdivisions of each of those grounds, like 9B and 9C as well. I think they are wrong saying that if they waive 9B, it doesn't mean they've waived the subdivisions, but why mess with that? If they're saying that's what they want, go ahead and list them all. And you do not assume, again, that any ground has been waived unless you explicitly ask for that ground to be waived. Because we have seen, and even when people do explicitly list them, we've found out when they go abroad and come back in that in fact CIS didn't list them all when they granted the U visa, and now the person's having trouble getting back in the United States because consulates can see what grounds they waived. And just footnote, we have literally been asking them for 20 years whether they could share with you and your client what grounds got waived, and their rationale for not doing is not substantive. It has something to do with their system. But I do think we need to keep pushing more on this, again, since this seems to be and is the vast majority of cases that are denied for U visas are based on inadmissibility grounds. We are happy to work with you on providing your evidence and arguments for discretion, the national or public interest. We do different webinars that focus a lot on that. I think the one main thing to understand is that this public interest is not necessarily the same as your client and your client's family's interest. Or to the degree that you want to emphasize that, we can help you frame it as public interest. It's not the same as family humanitarian relief, which is helpful when it comes to the adjustment phase. I don't think we're going to discuss that here, but just so you know, at adjustment, the AAO does have this ability to review discretion, and we have some good arguments if they're coming at you at adjustment with the same acts that they waived at the U visa phase for why that's improper legally. So let us know if you're running into that. And I think this is where I usually do my pretend you're at a barbecue trying to convince your neighbors that this is a person who should live in your neighborhood approach. Start with that. That's the best way, I think, to start with public interest, and then you can start getting into the lawyerly weeds with your arguments. Okay, so individualized arguments, right. Again, we talked about this in the last webinar about how to articulate some of these. I don't think this is as much of a problem with your waiver arguments, but it's still a really important rule, is that it's facts. It's a lot of detailed facts, not general statements, right? So he's helpful in our church is not a very useful argument. He runs the youth meetings on substance abuse every week and Friday at 5 o'clock is a more useful example of public interest, for instance. The more details, the better, because it makes it real to them. Even if it sounds boring and repetitive, it's better than general statements. So what does your client do for the community? And you can think of that in the big picture, or it could be your neighbors. Like, do they go help the elderly neighbor with, make food for her, or take her to the supermarket? So it's going to require delving into your client's life a little bit more. They're probably not going to reveal these kinds of things that, if they're nice people, they assume it's what everybody does. It isn't what everybody does, as we know. So you may want to actually walk through with your clients, what is their interaction with their neighbors? What is their interaction with the parents, other parents at the school, with their teachers? Their daily life that you wouldn't necessarily have gone through already for the basic eligibility requirements, but now you're trying to figure out what is their role in the community and how are they benefiting the rest of us by how they're living their lives. And this can be a challenge, especially with juveniles, and if you are having those issues, contact us, or with cases in detention. Those are the two big problem areas that we see with developing and marshaling proof for this requirement, but we have some thoughts on that. So practice pointer is that you may want to talk to others who can support draft supporting declarations, and again, this is so that they don't do those kinds of declarations that USCIS is just going to ignore because they're just general statements like he's really helpful and he's, everybody loves him kind of thing. Those supporting declarations have to have the level of detail that shows what we would call as lawyers the foundation for that opinion, as do your client's own statements. And one of the main themes you're going to be hearing from us from now on is that you have to think about all of this as creating a record for review down the line at this point. You can no longer tell your clients that it's likely that they're going to be approved, or how fast it's going to happen, or that they're not going to get put into proceedings, or any of the other things that they're afraid of. But what you can tell them is, we're working hard so that if that seems like it's going to happen, we're not going to let it happen without a fight. We are going to take this to the Administrative Appeals Office, and if we have to, we're going to ask a federal court judge to take a look at what's going on and see if that system can correct what we think are some infirmities in how they're applying the law that Congress created for survivors. As we've alluded to several times, there are several kind of general legal arguments that we're now asking you to routinely include. For instance, what we're suggesting in admissibility waivers, one of our arguments is they've never actually implemented the special waiver Congress created, the D14 waiver. Instead, what they're doing is they're taking case law on a D3 waiver that's related to crimes and glomming it onto the D14 waiver and never articulating criteria specific to survivors of crimes, as we assume Congress intended when it created a special waiver. So that's a legal infirmity. that the Administrative Appeals Office can review. They have yet to take it on review, but we're asking all of you in your appeals and your motions to include that argument so that they get hammered with it enough, maybe they'll start paying attention to it. And that is one issue that we think is ripe to take to a federal court judge, because failure to implement a law Congress has created is not acceptable under due process and the Administrative Procedures Act. Similarly, some of these things when they ask for like police reports or juvenile, the details of juvenile decisions, it's a similar due process argument that we want you to start making, even if you supply the evidence. And so even if you do supply evidence for the waiver that they're asking for, or you do supply the police reports, we want you to be making these arguments because what they're asking for we think is unlawful. And so, yes, you need to keep your case alive and do what you need to do for your clients, but we also need to educate the system so that we can fix this for everybody, especially the people who may not have attorneys and advocates like you helping them. And this last one, the lack of waiver review, as I was saying, kind of ranting in the chat here, that's purely regulatory. And we think that, that's, to me, such an outright violation of due process that the very same person who makes a decision is reviewing it and there's no meaningful review, and this is what's a constructive denial of an application? No, that's not acceptable. So I would love to move forward on that. If any of you are interested, let me know. I think this is back to you, Amy.
All right. So, as our last substantive topic for today, we wanted to talk about this issue regarding what is the admission period for U visa holders who have consular processed into the United States. And it's an issue that we're starting to see a little bit more in our TA. There's a little bit more chatter about it. And so we wanted to talk a little bit about this issue, to share what we're seeing, and then also see what you guys are seeing in your own practice. So the issue is that when somebody is consular processing on a U visa, there are times when the dates on their I-94, which is issued by CBP, Customs and Border Protection, are different from the dates on their 918 or 918A approval notice. So for example, let's say Vermont granted your derivatives 918A, and the 4-year period that's listed on their approval notice is from September 12th, 2016 to September 11th, 2020. So they've got their 4-year period. And then your client who's a U3 doesn't actually enter the U.S. on their U visa until November 14th, 2017. And at that point, CBP issues your client an I-94. And on the I-94, it says that your client's U3 status will expire on January 31st, 2019, right? And so the question that you're faced with is what controls, okay? So on which date will your client's U status expire? And we're not doing this as a poll because the answer is changing. So we're interested in your experiences, but this is something where we're seeing some developments in terms of USCIS's position. So historically, USCIS's interpretation was that the dates on the I-797, the approval notice for the 918 or 918A, controlled. So even in a case where the I-94 date expired before the 797, USCIS still went by the 797. And so what that meant practically was that you had until the expiration date on the 797 to file your client's adjustment of status. And then you would be using the dates on the 797 to determine whether or not this derivative needed to file a 539 to accrue the 3 years of continuous physical presence. Based on anecdotal evidence, what we're seeing is that the USCIS interpretation may have changed. We're seeing increasing reports from the field that USCIS is using the dates on the I-94 to determine when the U status holder's status expires. And so if we go back to this example, under the old interpretation, the person would have had until September 11th, 2020 to file for, in this case, they would have needed a 539 to extend their status to accrue the 3 years of physical presence. But they would have had until September 11th, 2020 to file that. Under current interpretation, it looks like they may be using the January 31st, 2019 date as the expiration of the U status. So you would have to file the 539 before January 31st, 2019. And we don't know for sure what they're basing this on because they haven't issued an official statement. There's no official written guidance that we have seen about this. But what we think is going on is that they have reinterpreted a couple of regulations in a statute. So specifically, we're talking about 8 CFR 235.1H, which says that CBP controls the terms and conditions of admission. So in this case, it would be the period of admission. And then CBP, when they're issuing the I-94, are looking at 8 CFR 214.14 G1, which states that the period of admission for a U derivative cannot exceed that of a U principal. So going back to this example, it may be that the reason why CBP put the January 31st, 2019 date on this I-94 is because the U1 status expires on January 31st, 2019. It's important to note that this reg is out of date. This reg was issued after the statute was updated. And so our argument is that CBP is relying on an out-of-date regulation when they're issuing these I-94s. But be that as it may, that appears to be what they're doing. And then there's also a statute that says that a passport for an applicant for admission, their passport must be valid for 6 months beyond the period of admission. This is for non-immigrant visa holders. And so if that's the case, then what you're looking at in this situation could be that the U3's passport was going to expire within 6 months from, was going to expire before September 11th, 2020, right? And so they issued the I-94 until January 31st, 2019, so that the person would have 6 months of passport validity after that date. So that may be why they're doing it. But then the question remains of what do you do about it, right? So if you have a client who has consular processed on a U and the situation applies, how can you fix it? How can you make sure that your client has the period of admission that they need? So in terms of practice pointers, we would recommend that whenever you have a U status holder who's consular processing, whether this is somebody who is coming in for the first time on their U visa, or even somebody who was in the U.S. when the U visa was issued and then who left and had to consular process back in. You always want to compare the I-94 to their 797 and see how the dates match up. They may match up, but they also may not. And so if your I-94 expiration date is before that of the 797, then you need to look at whether or not your client is going to need a 539 to accrue 3 years of continuous physical presence in U status before adjusting. And if they will, or if they don't need a 539, but you still have a mismatch on dates, then you would need to file the 485 prior to the expiration of the I-94.
What if the 797 expires before the I-94? I can't say I've seen that, but
I will say I have never seen that. It would be exceptionally unusual because the Department of State is using the 797 when they issue the U visa in itself in your client's passport. And so it would be really unusual. So you've seen it once. So how did that work out? I would be really curious to know how that worked out because it does sound really, really strange. It might have been a fluke.
Yeah, and while Noah's answering, Amy knows this is another thing I'm ranting a little bit about because think this goes with the theme of them kind of applying regulations that are designed for everyone to survivors in a way that harms them. And I think one of the ways we want to push back on this is that Congress very explicitly said that the special unit in CIS is supposed to be in control of all of these applications. And kind of everything we're talking about today is ways that other things are taking that control away. Because I think that's why Vermont felt like what it granted was what controlled, but now these CBP rules are kicking in a way that undermines, frankly, Vermont's authority. And I think we should push back on that. However, going back to another theme is you got to do what you got to do to make sure your clients don't lose their case while we push back on all of this. So Noah says they just entered. Sorry, did you want to read it? Oh, he hasn't gotten to the adjustment stage.
No, I was just going to say that ultimately, I mean, what you're trying to do is get a result from your client, right? And so you're trying to achieve the best possible result with the least possible hassle. And so sometimes it makes sense to just cover all your bases and play along with what they're telling you to do. But then there are other times when we really need to push back. So Noah is saying that in this situation where the 797 expires before the I-94, the clients had just entered, so he hasn't gotten to the adjustment stage yet. This is an interesting scenario. I would say that if we knew what USCIS's legal reasoning was for interpreting the regs and the statute in this way, such that the I-94 controls for them, if we knew that what their reasoning was, then I think we would have a better basis for making a recommendation in a particular case. I think because they haven't issued or we haven't seen any official statements about why they're doing this and why the policy or why the interpretation has changed, it's a little bit more difficult to know how they would respond in this situation.
And Amy, maybe Noah should contact you because you don't want to wait till you get an adjustment denial to find out there's a problem.
Right, exactly. You don't want to wait till you get a denial or an RFP to find out that there's an issue, right? So in weird situations like this, sometimes it's worth it to reach out so that we can just discuss it and come up with a plan so that you can avoid problems down the road. Okay. All right. So.
Okay.
And now, Gail, go ahead.
I think you're going to do the same thing. I'm just going back up to see if there are any questions that we haven't addressed one way or another. So, those of you hit other, what have we missed that you want to talk about? Or do you want us to elaborate on any of this? I think you had a couple polls after this, right, Amy?
Yeah. So the polls after this are really more for future webinar planning for us. It's really helpful to get some feedback from people about what kinds of topics they're interested in. But I also remember that in our poll at the beginning of today's webinar, we had some people say that there were some other questions, other issues that they were seeing in their practice that weren't listed on the poll. So we didn't see any comments at that point, but if people have experiences that they would like to share with the field or with us, or if people have case questions that they want to talk about, that this is the time to do it. We've got a substantial amount of time because we wanted to leave things open for the audience today. I would also say that if people have super case-specific questions, those are generally better raised in TA where we have more time to just dedicate to a particular question or case rather than the chat. But feel free to put whatever you want into the chat and then we can address it as it comes up.
Okay, so Martha, congratulations. Maybe you could explain how you convinced them that you were right about the travel to Mexico issue, since you did end up winning. But Paula's question, meanwhile, Amy, is what if you get an adverse prima facie determination for good faith marriage, which I assume is a VAWA? And I guess my question is, really just the prima facie they denied for good faith marriage? Because we need to see that. Because the prima facie determination is really to get access to public benefits, and it's supposed to be, quote, a statement of facts that, if approved, would lead to a grant. That's not a full filing. So, yeah. So, Paula, let's Oh, this is Martha. Okay, so then just so you know, good faith marriage is the big problem with VAWAs, whether this was at the prima facie stage, which I think is a separate issue if they're applying the wrong standard of prima facie, and we would want to see that, Paula. We want to see that. If any of you are getting prima facie denials, send them to us, because I think we have new adjudicators who were brought in from some other part of the agency who don't understand what prima facie means. But secondly, on good faith marriage, yes, that's a big problem that they are applying. I think a standard that's even higher for regular family-based marriages for VAWAs, and it is the main basis that we're seeing VAWA cases denied, and we've written 2 amicus briefs to the AAO on it. I don't think those cases, one of them I don't think has even been decided yet, but the other one still got denied, so they didn't pay attention to our arguments. But we still think they're good arguments, and again, you're creating a record if we wanted to go to the Board of Immigration Appeals, which you can with VAWA cases, or to the federal courts. So take a look at those briefs. They should be in Word version, so you can literally cut and paste. And then if once you've looked at those, it seems like their denial either really wasn't about any of that, or it's a different issue, contact us, because that's something we can help you work through how to submit. But again, remember those basic practice pointers we gave you about how to do declarations, especially with VAWA good faith marriage. You've really got to focus on the gory details. Take out, I always say, go through the declarations, highlight any adverbs, adjectives, or opinions, and replace those with facts that show the same thing. It's a good beginning anyway. Do you have any suggestions on that, Amy?
I would also say that from a purely procedural standpoint, in terms of dealing with an adverse prima facie determination for VAWAs, I think it's worth, in those situations, asking for supervisory review. Yes. Because, as Gail mentioned, the standard is so low, so that oftentimes it is a training issue. And so sometimes you can just deal with it through a request for supervisory review, and they'll go ahead and issue your positive prima facie determination. But if you're getting these, then we do want to see them, and we can also help you troubleshoot on, one-on-one how to address each one.
Okay, I'm going to ask a question that we need a little more information on, then we can move to another one. Magdalena, you recently received a request for evidence to prove that the client cooperated with the police. Is the original 918B, which is the certification from law enforcement, sufficient, or should you ask for a new police certification? So my question for you is this happening at the adjustment stage or before the adjustment stage? And if you could answer that, that would help. And then next question for you, Amy, is from Joyce. Client's workplace is not accepting her U extension letter to confirm that she is authorized to work and are asking for her 765. I've tried to get her 765 expedited, but CIS will not do it. What else can I do?
So, Joyce, just to confirm, in this situation, do you mean that your client is applying for U adjustment of status? And so she has gotten a notice from USCIS stating that her U status has been extended during the pendency of the 485?
It's at the adjustment stage.
Okay, great. Okay. So there are a couple things here.
Sorry, that was Magdalena. That wasn't Joyce. Oh, they're both at the adjustment stage. Yeah. Okay, good. There we go. All right.
So Joyce says yes. Okay. So there are a couple things that I would suggest here. So if the client is just showing the employer the U extension letter and the employer isn't taking it, the next step is for you as the attorney to write a letter explaining why your client is authorized to work in the United States. Sometimes it's helpful to throw in a couple citations and to put it on letterhead and make it sound more official. These have been sometimes effective in convincing an employer that somebody is work authorized. The next step from there, if that's not working, is sometimes, so the Department of Justice has an office for employment discrimination. They have an anonymous hotline for employers to call in to ask questions about work authorization, and I believe they also have a tip line. So this may be a situation where it's worth pulling in some resources from that office. Also, if you have in your area an organization that does employment justice or wage and hour issues, Sometimes getting a letter from that organization or a consultation from that organization can also be helpful. Oftentimes, when employers don't accept these letters, it's really coming from a place of ignorance. They really fear in ignorance, right, where they just don't understand what the law is, and they're so fearful of being found not in compliance that they're violating the law in another way. So sometimes when if you're able to, provide a little bit more support for the employer, then that can get them to come around.
Now, to your question, Magdalena, is that at adjustment, they're asking for evidence that your client cooperated with the police. Just as a footnote, this is, again, an area where they have reversed the burden that's in the statute. The statute places the burden on the government to show that they haven't cooperated. We just haven't, because we raised this at the regulation phase, if you look at the regulations, they actually give you all these other ways that you comply with this requirement. And I think that's their way of avoiding us basically litigating this because it's so clearly not what the statute says. So no, do not kill I don't think you should kill yourself showing this. For one thing, that's the wrong burden. And for another, if you've kept in your files every contact that you've had with law enforcement since that original certification, including is the case closed, did you ask if there's any further way that you could help? And they said, no, that's all you really need to show. If the case is closed, that's easy. You just show the case is closed. If it's still ongoing, then for those of you who are getting ready now, I do think it's worth like every year contacting the same law enforcement, saying, is there any more help you need? And then you write down in your case file, they said no, then that should satisfy them with this. If you're up against something more than that, you should let us know, because it may be time for us to point out to them again that they've shifted the burden impermissibly. Nevertheless, bottom line, don't kill yourself and contact us. So let's see. There's a bunch of stuff about work authorization here, Amy. There's EAD cards and green cards undelivered, and they're saying they delivered them, and they confirmed their address, so it's their word versus them, and they've had to file for replacements and pay fees. I guess she's also asking if any of the rest of you are seeing this, and I think on the last webinar, people mentioned that there's been a lot of EAD problems, so it might be worth collecting some, maybe doing a Google document and collecting some examples of all these problems, so that we could, it's easier if we could show it's systemic rather than an individual case. Do you have thoughts on that, Amy?
This is something that I also saw in my practice before, where it wasn't just EADs, it was sometimes other types of notices that USCIS said were delivered, but clearly were not. And so I think in terms of a Google Sheet, let's talk about this internally and see what the best way would be to collect the data and then what to do with it, right? Okay. Which is the ultimate question. In the meantime, this was never particularly fruitful for me, but it also does not take a lot of work to do this. You might want to consider submitting an ombudsman request about it, just to have somebody else inquiring about it. And also, you might want to ask them for the verification that they have that the document was delivered. Sometimes they'll use a tracking number. And so if they have a tracking number and it was a relatively recent supposed delivery, I think within the last year, then you should still be able to find the delivery information online. So it's worth at least asking them for it.
And another, if things really get bad, another useful contact, which is worth you cultivating anyway, is your constituent staff person for your members of Congress and senators, because they can contact the agency on behalf of you and your client as constituents to ask what's going on. So Lorena asks, or says, USCIS has been denying some of their hotline contacts, saying they need G28s for derivatives, I guess, as well as principals. Is that new? What are your suggestions?
I don't think this is new, actually, because the issue is that the derivative, if you're inquiring about a case that belongs to the derivative, right? So keep in mind that 918As are submitted by the principal, and so if you're inquiring about the 918A itself, for example, you should be able to use the principal's G28 for that. If you're inquiring about the derivatives I-192, so that is owned by the derivative, and so you would need a G28 by the derivative for that. And so if they're asking for this, then I would generally recommend getting a G28 from the derivative, which I know if your derivative is overseas or otherwise unavailable is difficult. But they're also not asking for an original signature necessarily. If you're going through the hotline, you can submit it as a PDF. So it's something where sometimes it's easier to do what they're asking for.
And mom can't sign for the kids on there?
If they're under 14, then certainly, of course.
Okay.
Yeah,
Okay.
always. If the kids are under 14, then either parent could sign in place of the child. But where you've got a derivative who is over 14, and it's their application that you're asking about, then I think you're going to need a G28.
Yeah. And by the way, Laura mentions that the Ombuds office is actually having a teleconference on mailing and delivery issues affecting immigration benefits. So I don't know if we have the information on that, Laura. If you want to share that with us, we'll send it out to everyone afterwards. That would be great. Then Charissa says, I'm having huge issues with hotline requests. 3 separate requests. It's taking months and several requests to get a response. Then the responses are ambiguous or wrong. Yeah. So you want to take a whack at that one?
I mean, I don't know what to say about that. I mean, it's a very common issue. We're hearing from a lot of practitioners that the hotline is just not as useful as it used to be. As Gail mentioned earlier, we still recommend that you try with the hotline. One, because sometimes it does help, right, or work. And then 2, even where it doesn't, if you're submitting a case intervention request through us, we still need to show that you tried the hotline. If you're submitting an ombudsman request, they still want to know that you did something to try to resolve the issue with USCIS. So it's one of those things where even though you know that it's probably not going to work, you still have to do it. Yeah. As for how we make the hotline work, unfortunately, we don't really have control over that.
We do have some, because we've been doing this for a long time, some idea of ways to set things up so it's easier for them to read. And those, we have what we call the intervention format, which is what I'll make you do if you want us to help you with getting things resolved. And generally what I ask you to do, or Amy will ask you to do, is to set up your request to the hotline following that format and then CC her. And that way it's ready to go with just some comments from us to headquarters and to the heads of the unit. And these days we aren't even necessarily waiting to see if they give a useless reply, because pretty much most of the time they are, although we do agree with you. Occasionally we'll get a good reply. But I do think the supervisor system is essentially broken down up there. I don't know what's going on, but I think they're overwhelmed. So you have to do it. You have to, quote, go through the motions so that we can show you're trying to use their system, but then we can still try to, you know, take it up to decision makers if it's not happening at that level. And Laura shared the ombuds. We'll share that ombuds information that Laura sent when we send out things afterwards, okay?
Great. The other thing I would say about the hotline is that I know that most of you guys are old hats at this, and I'm sure you're doing it right, but every now and then we still get an inquiry from someone who has, you know, submitted a hotline request without attaching their G28, and then is surprised that they didn't get a response. They will not respond to you if you don't attach your G28. And the other thing is to make sure that you have the right email address, because people used to use the @dhs.gov address, but they're not even checking that inbox anymore, so it's @uscis.dhs.gov. So just a couple baseline things to check, but as we've mentioned earlier, even if you're doing all of these things, there's a very good chance that you're not going to get a response from the hotline or that it's not going to be timely. So Claudia's giving a specific example of unhelpful emails back from the hotline, and that contacting the Ombuds office wasn't very helpful either. But Claudia, I don't know if we tried to help with that case, but we would certainly have sent, I would have sent, if I agreed with you it was unprofessional and snarky, I would have sent it to the heads of the unit and said, you know, forget the content. Is this really what you want your supervisor
to be saying to people. So always check with us to see if we have ideas beyond, the Ombuds office for how to fix problems. But yeah, I think we agree generally with you that these are becoming much less useful. But it's like, as with anything else, you got to still try to make the system work, and then we'll figure out what to do beyond it. Okay, I don't think I see any new questions, although Claudia is... so Lorena says they're getting work authorization automatically, yes, upon VAWA approvals, good, that were filed last year. Oh, yeah, that's what the statute says. You're supposed to get C-31 work authorization when your VAWA self-petition is approved. So they're doing the right thing, whether you're asking for it or not. And just to drop a footnote about the C-14 deferred action, I don't think people should rely on that as a prophylactic against removal. I think a lot of people thought that it would do that, but frankly, the reason it exists is that we didn't have a way to get work authorization for VAWAs until Congress added the language to the statute, which didn't happen, I don't think, until 2005. So they were using the deferred action system to get people work authorization up until that point. So it's never really been a prophylactic against removal, and it certainly shouldn't be relied on these days for that. I think the main reason now that people might prefer that is there are a few states that will only give driver's licenses with C-14, not C-31, although I think it's actually more common that the opposite is the problem. So anyway, let us know if you have other reasons that you want to keep pursuing C-14. Okay. Okay, so Jacqueline, there's no reason not to file C-14, but really, as I mentioned, it's not going to stop removal, and you really should, if they approve, you're going to get a work authorization based on approval. And I don't really see why that isn't at least as good as C-14 in terms of either convincing employers or stopping removal, because they actually have a status, right? It's the having the status that should really matter to ICE, not the fact that you've got deferred action.
So Gail, Jacqueline's question is about C-14 work authorization for U
Yeah.
visas. And the U visa context is a little bit different from VAWA because at the point where you're requesting C-14 work authorization, it's for when your client is on the U visa wait list.
Yeah, and actually, yes,
we think that.
Yeah.
So we think that you should file for the C-14 work authorization. You can even file this at the time that you're filing the 918 to cut down on the wait time once your client gets on the U visa wait list.
Yeah, sorry, but that is an example of when we use deferred action as work authorization, because for those of you who don't know, the wait list is purely regulatory. It's not in the statute. So again, the only way to get people work authorization through that regulatory system was C-14. But one thing I'm going to put in here is I would like you all to consider to start asking for work authorization under the 2005 bona fide standard that Congress created in 214p6. Because we have been pushing them a lot on that in the federal courts, and we're seeing some movement in our favor. So if you're interested in that, let me know. You don't have to necessarily litigate it, but it would be great if everyone started asking for bona fide work authorization.
And then, Jacqueline, I'm seeing that you have been getting some of these C-14 work authorization requests rejected recently. So I'm very curious about that. I would definitely want to know more. If you'd want to shoot me an email, then I'd really like to hear about this experience, because we had not been hearing about that from anyone else. And so if it's wider than that, then my email is going to be on the last slide. So it would be useful to have this information and to hear from other practitioners, too, if you're also seeing this problem.
Yeah, so you know, our argument is that the bona fide work authorization should come before the waitlist authorization, which is why we're really pushing for that. And I think we have a sample request from the folks out in LA who have been doing it for all of their clients, if anyone's interested in seeing it. Is that it? No more questions? Oh, here we go, big one.
Oh.
Want me to read it? Okay, so I'll read it to you, Amy. Carmen's has a U3 applying for adjustment, but But he didn't consular process until a month before the end of 2015, because the U visa was approved from 2015 to 2019. Just got a request for evidence, I don't know what this means, for 2015, but he didn't have anything to submit. He did, request for evidence for humanitarian discretion, I assume is what you're saying.
So that your physical presence.
Oh.
An adjustment application, yeah. He didn't have evidence to show continuous physical presence for 2015 because he didn't come until a month before the end of the year.
All right, then you just, since you read it better than I did, you go ahead and answer it.
All right. So he didn't have anything to submit. He didn't go to school or work. And Carmen's thoughts were to have him write an affidavit about how he entered in December of 2015, and also an affidavit from a family member who brought him by car from Mexico, and also resubmit his passport with a stamped date. Any other ideas? So I think that what you have there is good. Also having him make an explicit statement about how he never left the country during the month of December 2015 or ever, theoretically. And then also assuming that he was living with someone during this time, right? If you're saying that there's no other systems evidence, like if he didn't have a lease in his name or any other kinds of other extrinsic evidence like that, if he was living with people, even if they were family members or friends, having them write an affidavit about how he was residing with them during that month, and so they saw him in the household and they know that he did not leave the country because he was there every day. Something like that could also be really helpful.
Right. There's got to be some evidence of his presence, right? I mean, unless he lived in a hole, there's got to be some evidence that he was here during that period. So, yeah.
And then the other thing I would say is that it's possible that he didn't start doing this until later on, since he was such a recent arrival. But sometimes when people first get here, there's like a whole bunch of administrative stuff that they need to do. So, for example, applying for an ID, applying for a driver's license, applying for a social security card, even applying for a job, even if you didn't work. And sometimes there are documents or other evidence related to those administrative tasks and logistical things that people do, signing up for a cell phone when he got here or something like that, that could be useful evidence.
Okay, so now what is the problem with U3 adjustment applicants who marry after the U3 is approved but before the adjustment is filed or is adjudicated? What's the problem with that?
So since Laura's asked me for updates, I'll assume, but just for everybody else in the audience, just to make sure we're all on the same page here. So historically, Vermont has treated U derivatives at adjustment as being independent of the U principle. And so even if a U3 had married after their U3 approval but before their adjustment of status, Vermont had historically not raised that as a problem. So even if the U3 got married, it was still okay for adjustment purposes. The reason why there is some debate about this is because under the regs, USCIS has the option to revoke the status for derivatives whose relationship to the principal has terminated. And so if the U3 has gotten married, then their relationship, their qualifying relationship to the U1 is no longer in effect because they are no longer considered a child under the INA. So that's the background for this question. In response to Laura, we haven't seen any changes in how Vermont is treating this kind of scenario. I do think that where we are seeing potential areas for concern is that Vermont is using its discretion. There's a bit of development in the way that Vermont has been using its discretion generally. And we don't know for sure how they're going to apply discretion to this kind of scenario in the future, right? It's speculative. So we don't have anecdotal updates at this point as to how Vermont's treating the situation, but I don't think we can say how they would treat the situation in the future. Does that make sense?
Yeah, and I'm asking Laura to let us know because I actually think it would be unlawful for them to change. I mean, they've already agreed that it's a statutory construction argument, right? If they start using discretion to deny contrary to the statute, we'd push back hard. So that's why, Laura, we're wondering if there was a reason you were asking this. Oh, she didn't. Okay. Yeah, no, I don't. So can you pass? We can't be on the VAWA experts listserv all the time, so it'd really be helpful if those of you who are when issues like this come up, suggest people actually contact us and not just talk to each other about it. Because sometimes rumors spread and they're just wrong. So, or if something is happening, we want to know about it right now, so we can take it to the heads of the unit and to headquarters right away and say, "Hello, you remember you told us this?" That's what the statute says. Because we do have to do that periodically with them, so you know. Let's see. Gabrielle, you didn't answer my question, but I'll go ahead and ask it, which is, can a false claim to citizenship waived at the U visa be waived in the citizenship application? And I was trying to get you to just think through what would be in the NATS application where this could come up. But so, Laura, why don't you walk us through that? False claim or any of these things that you reveal in a U visa that's waived, how could they become a problem at NATS? Amy?
Yeah, so I think if the false claim has been waived for purposes of the U visa and the person properly adjusted, then they should be okay for the NATS. Have you seen otherwise?
No, but I do think people are confused about good moral character, because 101F talks about false testimony. False testimony actually is a term of art, legal term of art with case law associated. So even fraud, normal immigration fraud, and false claims are not necessarily false testimony under 101F. But that is where the intersection can become problematic for U visas, is between the 101F good moral character phase at NATS and any things that are in 101F that you may have waived earlier. Now, we could make these arguments that we're trying to make about kind of like, this is like race judicata, but so far those haven't really worked. And I think it's better to at least flag them ahead of time to decide what you're going to do down the line about them. So, Lorena, if we file the U visa and the application arrives a couple days after the certification expiration date, what do you recommend we do once we get a second certification? Refile a brand new application or supplement? So, first question for you, Lorena, is when you say arrives, so when you sent it in, you knew that it was going to get to Vermont late, or did you actually send it in time and they're telling you that they got it late? Because that's a big difference there. Okay. Well, so we can answer it both ways. Amy, are you still there?
Yeah, I'm here.
Hello? Okay, I'm just not hearing anything. It's hard when it's only us talking. So let's assume for the moment that you did file it timely, like it was supposed to get there on Friday and they're telling you they only got it there on Monday. This happens all the time. Don't assume they're right. If you have proof that it actually was received at the building by the deadline, then let us know, because we've over and over again, we've had to point out to them what the rules are on this, and over again they ignore them. But ultimately they agree we're right. So, but then let's assume that you filed it and it didn't actually get there until after the certification lapsed. Do you have any thoughts on that, Amy? Should they get another certification? Should they file a whole, even if they do, should they file a whole new application, or just, quote unquote, supplement the one they filed with the certification? What do you think?
So historically, I have filed a new certification as a supplement as opposed to a brand new application. I think the trouble that we have is that when we're filing now, these cases aren't being adjudicated for several years. And so sometimes it's a little bit hard to know how USCIS's practice is going to change in the future. And I think one of the issues with filing just a new certification as a supplement is, if I'm remembering the regs correctly, the certification needs to be, or the application needs to be filed within 6 months prior, within 6 months of the certification. And it's the wording of this 6 months that I'm trying to look up right now.
Yeah, and while she's doing that, I think the problem is that, you know, this new memo that says they can deny without notice. This is a basic eligibility requirement. So I think I would argue, if I were them, that it was not properly filed at the time when they got it, because the certification was obsolete. So my suggestion would be withdraw the current application and ask to replace with a new one. But And then while she's looking for this language, this is another area where there's nothing in the statute that has a deadline for certifications. But again, it's probably not worth fighting with them about that in this context.
Yeah, so I found the language in the reg that I was looking for. And so the issue is that the initial evidence must include the certification signed by a certifying official within the 6 months immediately preceding the filing of Form I-918. And so the issue with filing a new certification as a supplement after you've already filed your 918 packet is that depending on when you're getting it, if you're getting this new certification after you've already filed the Form I-918, then it's not being signed within the 6 months immediately preceding the filing of Form I-918. It's being signed after the filing of Form I-918. And so I think that's potentially a spot where you might run into trouble if you were filing it as a supplement as opposed to as a new application.
So Carmen, Carmen had posted, this was about the 3 years continuous presence, said all the stuff happened in 2016, which I guess I'm not sure that matters, right? Because it has to be 3 years continuous presence. So the issue is you're going to want to have to show, you want to have evidence from all 3 years. But I might be missing why that matters.
I think she's responding to my answer, which was suggesting various things that she might want to look into to see if they happened in December 2015. So if all these things happened in 2016, not 2015, then maybe those don't apply. But it's worth looking into seeing whether the family took any photos in 2015, like maybe they took a picture of him outside the house, maybe they were showing him around this new neighborhood and they had taken pictures of your client in various locations. Hopefully there's a time and date stamp, maybe even a geolocation. If you have that, that could be helpful. Also, cell phone records will oftentimes have a geolocation on them, so if you're able to get those from the cell phone provider to show that it was his phone, or sometimes even Facebook, I think, has geolocation on it, which is a little bit frightening, but sometimes helpful. So if he was active on social media during this time at all, then sometimes that can provide a little bit of evidence as to his location as well.
Wow, a little scary. But Carmen, if you have further questions, or when people have this kind of case, this is what we're here to help you with, right? If you're flummoxed about how to prove something, we'll brainstorm with you, because that is the beauty of the any credible evidence standard, right? Is you say, look, you know, he's undocumented, he's young, he doesn't have all these normal documents people would have, so we couldn't get any of these other things, but here is what we got, and that shows that he was physically present here. So. Okay, well, so we've still got 15 minutes if people want to post questions. Maybe while we're waiting for people to ask more questions, Amy, you want to do your polls on the next few slides?
Sure. Okay, so we can go ahead with those, but if people have questions, please go ahead and still put them into the chat. Okay, and so the next couple of polls we have are really for helping us plan future webinars. Because we had been considering doing a series or at least a webinar on removal proceedings, strategies for continuances, termination, administrative closure, and other issues around representing clients in removal proceedings. So we're trying to get an idea if you guys have clients who are in removal proceedings so that we know at least whether this would be at all applicable for you guys.
Yeah, I think we have enough. I would say, yeah, 20 people is definitely enough. We should definitely go ahead and do that. Good to know.
All right. And then the next question, the next poll is related. I'm going to end that one and then move on to the next one. All right. And then next up, do you have at least one survivor client who has an outstanding order of removal? Okay.
All right, good. All right, so we got to do a series for you on removal. I mean, there's basic removal defense, and then there's a lot of special survivor arguments you can make for removal and challenging removal. So this looks like this is a yes, Amy. I'd say.
All right. So thank you, everybody, for those responses. It's really helpful for us to know, what's applicable for you guys, but also what's helpful. I'm going to be putting in a link for our post-webinar evaluation poll as we wrap up here. And we have questions in there for you guys to tell us what topics you would like to see, what's helpful about today's webinar, what's not helpful. It's really useful for us to get feedback from you guys so that we can make sure that the trainings that we're putting on are applicable and relevant and helpful for the field, because that's ultimately what we're trying to do. And I am really not seeing any new questions in the chat. And so let's just make sure that you guys have information on contacting us. So as many of you know, in addition to these trainings, we also provide individual free technical assistance to OVW grantees. And so you don't have to be an attorney, you don't have to be a DOJ rep. Anybody who's working with survivors in a capacity related to their immigration remedies can contact us for TA. And so we do ask that you go through this link. We know that historically a lot of people have emailed us directly for TA. We're asking that you go through this link to submit it through our system because it really helps us with tracking. And so if you email us, we're probably going to ask you to go through this link anyway. So you might as well do it to start with. In addition, there are some resources on our website. We know that the website can be a little bit difficult to navigate, so if you're having trouble finding resources, shoot us a TA. We're happy to help you find them. And also, I don't know if this is too premature to announce, we are moving things over to a new website soon, so we're very excited about this and hope to announce the debut in the coming weeks.
Oh, you're so much more hopeful than me.
And then I would also say that a lot of our most useful information is coming from you guys, from practitioners, because we don't do direct service. And so we only hear about what is happening in the field, what's happening on the ground through you. And so it's best if you guys can send us success stories as well as times when you guys are having trouble with USCIS so that we can see what's working, what's not, and share those things with the rest of the field.
So Amy, there is a question that came up that I've been answering based on my somewhat probably obsolete experience was, what about like video or audio evidence on a CD, used to be tapes, especially like showing the abuse, like if you have the abuser calling voicemail or you have some social media or something like that. Can you submit those without a transcript? Do you have any experience with that?
I don't know the official answer to those questions. What I've heard from non-Vermont Service Center offices of USCIS is that the reason why they can't take CDs and flash drives, for example, is because of security concerns with their network, that they're not permitted to use those types of technology when they're coming from the outside. But I don't know that that is necessarily true for Vermont Service Center. I haven't heard it from them.
Yeah,
so I actually don't know.
They used to tell us that they would listen to it, but that was when it was just a few really good adjudicators. So I can't. I mean, the worst that happens is they tell you they can't do anything with it, right?
Right. So, I mean, I would say that if you really wanted to be safe, you would get a transcript and submit it on paper. And then in addition, you can also submit the CD. If for some reason you can't do that, you could try submitting the CD to see what they do with it. But I think the answer for now is that we don't actually know. And then to answer Jasmine's question, the slideshow is downloadable. It's in the files right below your chat box. So there's a little box under there that says Files and then Name and then Open Case Rounds Final.pdf. And so that is the slideshow. And it will be emailed in addition.
Yeah, and also, I'm sorry, I was replying with a recording. So that's a special YouTube channel we have for you all, and she'll send you the YouTube link for that if you want to listen to it again. Okay, whoops, Carly's typing. Carly. She has a question. Any of you don't have questions, you can leave if you like. But we'll stay on till 4 o'clock.
You can always leave if you like.
So, not required to stay.
Although we are, I will say, just for everybody to keep an eye out, we're working on getting CLE accreditation for some of our webinars.
Yes.
And so in the future, as we start getting CLE accreditation for anybody who is interested in that, you would actually need to stay till the end of the webinar. So just a heads up for the future.
I'm glad we're helpful to all of you. We really do want to know how we can be more helpful, so let us know. Carly, did you have a question? We know Carly for many years, that's why we're laughing. Okay, really confused about the discussion on employment authorization while the 485 is pending. Her understanding is that you merely filing the 765 is not enough, and merely having the U adjustment pending isn't enough. You're eligible for employment authorization, but you don't have any employment authorization. Is she completely wrong? She's doubting herself here. So yeah, let's review what people should be doing.
So my argument here is that U status holders are employment authorized incident to status. And so it's almost like asylum asylees, where by virtue of holding this status, they are employment authorized. And I can send you the links to the citations for this after the webinar. And so when you file the 485, if you file timely, the USCIS sends you the extension notice that states that your status has been extended. And of course, we know that statutorily your status has been extended. You are in U status while the 485 is pending. And so if you are in U status and your work authorized incident to status, then your work authorization card is evidence of your work authorization, but I think that legally it shouldn't actually be required as evidence of work authorization. It's just that that's what everybody's used to seeing, and so that's what people have been requiring. And so that's my basis for the argument that the fact that your U status is still valid means that you are still work authorized, even though you don't have an EAD.
And this is where the extensions come in, right? It's to try to keep that alive if you've run out of the technically out of time?
So this is assuming that your 485 is filed timely. If your 485 is filed untimely, then I think that's much more problematic because arguably you are not in U status, and so you wouldn't be work authorized until your C9 EAD is issued based on the pending 485.
Good. And then Viana asks, is it automatic, the work authorization renewal, or do you have to reapply?
You have to apply. You have to submit a 765 for a renewal.
And then just a footnote on what Amy said, even if somehow you've missed the filing for the adjustment, say you inherited a case or whatever, contact us, because we do have a bunch of arguments to try to get your client back in the system. Can help you with that. There's always ineffective assistance of counsel, whether it was prior or you. Okay, I think everybody else. Oops. Does a new U certification need to be submitted with U visa adjustment? No. No, is the bottom line answer is absolutely not. Their own regulations say that it's not, and the regulations discuss all the other stuff that you can supply. And again, we're happy to work with you on your individual cases, because some of it's going to have to do with what you've got and where the case is and that kind of thing, what you're going to argue or what you're going to supply. But yeah, don't kill yourself on it. You do not need a new certification. You can either show ongoing helpfulness another way, or you can show the case is closed. And we will push back hard if they require you to get a new certification. It's absolutely not required by the statute. Okay. Does anyone have anything to say to us besides thank you? If yes, why don't you flag that for us? And if not, we appreciate all your thanks, and we're very thankful for you. Anything final you want to say, Amy?
Nope, that's it. We're going to be sending out the registration and everything for the next webinar in the next few weeks, just to give you a heads up as to what we're expecting for the next year. We're planning to have a webinar on immigration legal research intended for attorneys, DOJ reps, anybody who's representing survivors who feels like they could use a little refresher on where to find statutes, regulations, legislative history, Federal Register notices, and all those sources of law that can be useful in our work. And of course, we're planning something on removal as well. And if you guys have ideas for what you would like to see trainings on, please let us know. And I'm also putting into our chat box right now our evaluation form. So this is a link to our web evaluation. It is anonymous. Please fill it out. Let us know what worked, what didn't work, any ideas you have for webinars and other trainings in the future.
Yeah, and just to let you know, we are actually paid by OVW to do intermediate and advanced immigration law training, but that's why Amy's going to put together this resource on more introductory. And if you need more introductory, we can connect you with others or other resources that OVW has that can kind of bring you up to speed so that you hit the ground running for our stuff. Oh, and we do TA on anything, so yeah, it's just their trainings tend to be more advanced than you may find in other places. So, all right, well, and thank you to our TA2TA pals for making this work for us today, and again to all of you for working with survivors. Couldn't do it without you.
All right, thank you, everybody.
Bye.